Assalamu alaikum, welcome back to Just Law on IQRA TV. I'm your host Ilyas Bulbulia and I'll be with you until the end of the show. Just before the break, I had a couple of questions about individuals who are sponsors really, who are in the UK, they have a marriage, maybe there's a problem with the marriage, etc. They've gone abroad and they've remarried, and the questions really relate to mainly how can an individual then sponsor their second husband or wife to come to the United Kingdom. The basic position really is that as far as the immigration rules are concerned, where the first marriage has broken down, you must obtain a divorce from that first marriage. Now, even if it's the case that the first marriage has broken down and maybe there's just been, if it's an Islamic marriage, you've just had an Islamic divorce in the UK, even if you've done that, that won't be sufficient to sponsor the husband or wife to come to the United Kingdom. Where there has been a proper valid marriage, there has to be a proper valid divorce which takes place. Now, in the United Kingdom, where you're properly married in the United Kingdom, an Islamic divorce may be done through the Sharia Council or maybe done by the parties themselves with family members, etc. And if it's just an Islamic divorce, which is the end product of that, that in itself will not be sufficient. You have to obtain a proper divorce using the UK court system. So one has to apply to the court, the family courts, and obtain a proper divorce. Only then will it be possible to sponsor the second husband or wife from abroad to come to the United Kingdom. Now, it happens a lot, and it's unfortunate where there's been a marriage, parties have lived together many years, for whatever reason the marriage has broken down, and what's been done is that the parties have had an Islamic divorce. And nothing more has been done. The parties, for all intents and purposes, are actually divorced. They don't live together. It's genuine. The marriage has broken down. Now, they think that in itself will be enough. They sometimes come to you and say, well, look, you know what? Not only do we have an Islamic divorce, but look, I've got a certificate from a Sharia Council with the stamp on it. It looks very official. There's a letterhead. There's a nice stamp on it, etc. I mean, that may be helpful, that may be necessary in certain circumstances as far as Islamic divorces are concerned. But as far as English law is concerned, it's not sufficient. You have to obtain a proper divorce. Now, the thing that confuses matters even more, let's take the example of somebody who wants to get married, first marriage has failed, they're going to get married in Pakistan, is that when they want to get married and it's the second marriage, the fact that there's an Islamic divorce certificate, that would be sufficient for somebody to remarry, even for a woman to remarry in Pakistan, because as far as Pakistan is concerned, there has been an Islamic divorce. They're okay with that. That lady can then remarry. So they think, well, we were allowed to remarry in Pakistan. Surely it must have been sufficient then. Well, that's really something for that's as far as the Pakistani laws are concerned. Pakistan laws are concerned, that may be okay. But as far as UK laws are concerned, as far as immigration rules are concerned, you must obtain a proper, valid divorce before you're going to be able to sponsor your husband or wife to come to the United Kingdom. I hope that answers the last two questions that we received just before the break. Now, as always, it's a live show. Although we're dealing with a specific area of immigration rules today, whatever your questions relate to, immigration matters, whatever it is, please feel free to pick up the phone and give us a call. Now, what I was looking at just before the break was in relation to sponsors in the UK who are European nationals, and what they want to do is they want to sponsor their husband or wife from abroad to come to the United Kingdom. And we were looking at the differences for somebody who's a UK national, wants to call their husband or wife over, contrasting that with somebody, the sponsor is a European national who wants to sponsor their husband or wife over. One of the differences is that for a European national whose husband or wife is coming to the UK on a settlement basis, they don't have to pay a fee. They don't have to pass an English test, and the way that the English requirement is met is much easier as well. So a couple of fundamental differences. And just before the break, we were looking at the accommodation requirement. Where a normal spouse application is met, there are quite strict accommodation requirements. Not only does there have to be sufficient room for a husband or wife to be able to come and live in the UK, in terms of enough space in the house, etc. Normally has to be like a housing report submitted as well. So not only does there have to be a proper report done and demonstrated that there is sufficient space, the accommodation in question also has to meet certain requirements in terms of it has to be free of certain hazards, etc. Most houses are free of that anyway, but there are specific requirements which need to be fulfilled under the immigration rules, where the sponsor in the UK is British and sponsoring the husband or wife to come to the UK. Contrast that with the situation where the sponsor is a European national. In that situation, there are no strict rules in relation to accommodation. Indeed, there are no rules whatsoever relating to accommodation. So you can, if you want, not say anything at all in the application about accommodation which will be available for the husband or wife who's joining the European sponsor in the UK. No need to submit proof of who owns the property, no need to submit any tenancy agreements, no need to submit any housing reports, no need to submit any letters from owners who own the property to confirm that the person coming from abroad will be allowed to stay at that property in the United Kingdom. So there is actually no rules relating to accommodation whatsoever. The key requirement for somebody who is coming to the UK to join a European sponsor is really that they should be in proper employment, or they should be in proper self-employment or studying, etc. In most cases, the key requirement that needs to be fulfilled is that there has to be evidence of employment. It doesn't have to be 6 months, it doesn't have to be at a level which meets the 18,600 requirement. As long as there is evidence of genuine employment, that is one of the main requirements which is fulfilled. Now, the other requirement that I want to look at then is the evidence relating to the marriage being valid and the relationship being genuine as well. Now, in that respect, the rules are very, very similar. In the same way that in a normal application, you have to demonstrate that you are married legally to your husband or wife abroad, not just married under religious laws or customary laws. It has to be a legal marriage. So not only do you have to demonstrate that there is a legal marriage that's there and it exists, the rules relating to the genuineness of the marriage are very, very similar as well. Now, in a normal application, the rules talk about the relationship having to be genuine and the relationship needs to be subsisting. So that's in a normal application where the sponsor is British. In a European application, the wording is slightly different, but in reality the effect is the same. For European applications, what the Home Office looks at is that the marriage is not one of convenience, so it's not been entered into to try and obtain some kind of immigration advantage. So although the wording is slightly different, the evidence which is submitted in relation to the validity of the marriage and the genuineness of the marriage and the fact that the marriage is subsisting, the evidence which is submitted is actually the same in reality. So what is it that is submitted in terms of evidence? Well, normally there's evidence submitted of the parties spending time together. In a lot of these cases you find that the European national actually was living in a European country. Let's take, for example, Italy, has been living there for many years. and they've acquired their nationality in that European country, Italy for example, and although their husband or wife is abroad in India, Pakistan, Bangladesh, wherever, all they've done is gone back over the years to see them, and they've gone back on a weekly basis. Now, obviously, where the marriage has lasted for a considerable period of time, you have to demonstrate that you have been in regular contact with your husband or wife. So there have been regular trips that have been made to that home country in India, Pakistan, wherever it is. So the evidence of contact obviously needs to be submitted. So evidence that somebody's been back in terms of passport stamps showing entry and exit for that country, in terms of photographs together, and again, where there have been children, you have different photographs over a period of time showing how the kids have grown up. So you'd submit evidence in relation to that as well. So that's really the starting point when you are attempting to demonstrate that this marriage, this relationship is genuine. Obviously you will submit the marriage certificate, but in terms of the genuineness of the marriage, evidence that there has been regular actual contact between the parties over a period of time. Now, although there's no strict rules relating to how often the sponsor needs to go back to their home country to see their husband or wife, I think as a rule of thumb, my view is that as a minimum, there should be one trip a year. And I think in my experience, that seems to be, generally speaking, sufficient. So that's the level of contact that there should be in general terms. Now, that's actual contact where both parties see each other in real life. Now, the reality is that day-to-day contact will actually be by way of telephone calls and messages to each other. So there needs to be evidence of the parties being in, sort of, if we call it indirect contact. So there would normally have to be evidence of telephone calls over a period of time. There would also be evidence of messages being sent to each other. So on the one hand, you've got evidence that the parties have been in actual contact, maybe once a year, and this indirect contact, if we call it that, in terms of telephone calls and messages between the parties. So that's the kind of evidence that needs to be submitted. The other sort of evidence that you normally come across in these cases is that the husband or wife in the UK, who's the European sponsor, would normally be sending some kind of amount. We'll take the next call and we'll look at this in greater detail after that. Hello, assalamu alaikum.
Welcome, Sam. I've got a question about the indefinite leave.
All right, okay, yep, that's fine.
So I want to apply for my indefinite leave because I'm on a tier 2 visa, but I will be 10 years in January.
I understand, okay.
But my dependent, my husband, won't be like 10 years.
Okay.
So he's been here for 3 years.
I understand, yeah.
So how can he, do we have to extend the visa or how long will it take him to get indefinite leave?
I understand. You just need to be careful with this because when you qualify for indefinite leave, you will qualify for indefinite leave under the long residence requirements. So you won't be applying for indefinite leave under the points-based system, which is absolutely fine. You will get your indefinite leave under 10 years long residence. But there are consequences which follow from that. Now, if you obtain indefinite leave under 10 years long residence, it means that your husband will not be able to extend his visa under the points-based system. What he will have to do is extend his visa as the spouse of a person who is settled in the United Kingdom. So in practice, what will happen is you will apply for indefinite leave to remain, you will get your indefinite leave to remain, and then your husband's visa should really be transferred onto a normal spouse visa. So the spouse of a person who is settled in the UK. Now, whether it's done straight away or you wait for the visa to expire, either should be okay. Now, whatever you do, whether you switch your husband's visa now or let's say you do it when the PBS dependent visa expires, the requirements that you will fulfill are going to be different, because what you will need to show is your level of income will need to be demonstrated. You'll have to meet, the husband will have to meet the 18,600 rule, plus he will need to pass the English test, etc. So you will have to prepare it in such a way that after you get your indefinite leave, your husband's application as a normal spouse application from the UK is going to succeed. So that's the way you're going to have to do it. Now, the other problem is, my understanding is, once he goes into the spouse category, the other problem is that I think he needs to complete 5 years in that category. I don't think he can count the time spent as PBS dependent. I might be wrong on that. I can't recollect correctly what it is. But the starting point is he will cease being a dependent, a tier 2 dependent. And once you obtain your leave under the long residence rule, he will become a normal spouse of somebody who is settled in the UK, and it's those requirements relating to that category which will need to be fulfilled. And the reason for that is it's because of the category in which you are obtaining your indefinite leave to remain.
Okay, can I ask another question?
Yeah, of course you can. Yep.
So if I don't get indefinite leave based on a long residence, and if I wait for my tier 2 to finish, and that would be in the next, in the next 3 years. So would my husband be able to apply as a dependent?
He would. Yeah. He would then be able to apply as a dependent. To be quite honest, my view is this: that if you do qualify under long residence, my personal view is, from a practical point of view, apply under long residence and get your indefinite leave to remain. Because the problem with tier 2 is you are dependent on your employer. You just don't know what's going to happen. And if you said to me, look, I can apply under long residence in January, or I can apply in March, April, May under my tier 2, I'd say, okay, it's only a few months wait. But if you're saying there's going to be a long wait, definitely get your indefinite leave to remain on the long residence. You see so many cases where things go wrong, where people are waiting. I think get your indefinite leave under long residence, and then when your husband's visa expires, just be ready to extend his visa as if he is the spouse of a person settled in the UK. 18,600 requirement, English language requirement, they're not terribly difficult requirements to fulfill.
Yes. So 18,000 would be, for me, I would be earning 18,000, or him to be earning 18,000?
Either, or combined. It could be you, it could be your husband, because he's obviously legally in the UK entitled to work. So your income, his income, or combined income. Now, the reality is this: if you're in tier 2, your income will normally be quite high anyway. So I'm hopeful that the income requirement doesn't present any problems. It's just a bit of hassle, but it's still the best way to do it. You obtain your indefinite leave when your husband's visa expires, or even now you switch him into you take him out of the dependent of a points-based system migrant category. He comes out of that and he goes into the normal category. When British sponsors and people with indefinite leave, when they're sponsoring their husband or wife to come to the UK, or they're extending their visas, the category which deals with that, he goes into that category. I think that's the best way to do it. It may be that the time, I think it is the case that the time spent as a PBS dependent can count towards the 5-year rule. I think it can. I just can't remember 100%, but I think you can count it, so you can combine it. But I'm not 100% sure. It's just something which has just slipped my mind completely. I can't.
And that's the same with my daughter as well, who's 3. So that would be the same situation with her as well.
Yeah, same situation at all. With the daughter, the sister, obviously you're together. The daughter will qualify for indefinite leave as soon as your husband qualifies for indefinite leave. She will qualify. Where was your daughter born, by the way?
In Pakistan.
In Pakistan, all right, okay. I mean, if she had been born here, she would have been eligible to be registered as British, but because she was born abroad, she doesn't become eligible to be registered as British. You'd just have to wait until your husband becomes obtains indefinite leave. At that stage, she'll obtain indefinite leave, and she will then at that stage qualify for a British passport or nationality. Okay, brilliant.
Thank you.
Thank you very much indeed. Thank you very much for your call. Thank you. So just going back to what we were discussing before, which is the sort of differences between those sponsors who have European passports. So they may be here with a French, Portuguese, Italian passport, and they're sponsoring their husband or wives over from abroad. And what we were looking at today is how easy it is in terms of there's no fees to pay, there's no English language requirement, the income requirement more easily fulfilled, there's no accommodation requirement. And what I'd reached the sort of towards sort of near the end of the show, what we were looking at was finally in terms of the marriage and in terms of the relationship, those requirements are very, very similar. So even though it's a European sponsor, you still have to demonstrate that the marriage is genuine. And what I was then looking at is that there is a requirement that you must demonstrate that the marriage is genuine and subsisting, although the wording under European regulations is slightly different. So you are looking at demonstrating that you visited the home country on a regular basis. Hopefully you've met each other once a year. You're also demonstrating that you are in regular contact by telephone, and you are hopefully in regular contact by sending each other messages. This all demonstrate that this is a genuine application. There's no sham marriage here. The other aspect I was looking at just before the phone call is that generally there would be evidence of money being sent by the sponsor in the UK, whether it's sent by Western Union transfers or bank transfers. There would normally be evidence of that as well. So we do have to demonstrate that the marriage is valid and is also genuine. In that sense, the requirement is still the same, irrespective of whether the sponsor is British or the sponsor is European. Now, just on that point, just a couple of minor points in terms of evidence of the relationship. Main evidence is always evidence of actually seeing each other, spending time with each other. Evidence of telephone calls, messages, money. In my experience, they're the four main pieces of evidence that you should put in. And that should ideally cover as long a period as possible, not just the last 3 months or 6 months. If you've got evidence which extends over the years, the number of years that you've been living separately, that would be better. So if you've lived separately for the last 5 years because husband's been here working away, wife's abroad, and if you've got evidence which covers that period in terms of photographs together, in terms of visits together, etc., try and cover that period. Then there are other little bits of different pieces of documentary evidence that you can submit, and these are not really that crucial. It could be that you receive correspondence, Eid cards, etc., and you've kept them, obviously submit that. If you've been on holiday together somewhere, you've got hotel bills in your joint names, again submit that. There may be gifts that you've purchased for your spouse, you've sent that abroad, and you've got evidence of the gifts, you've got evidence of that being posted abroad, keep hold of that as well. So you've got that kind of additional evidence that you can submit as well. Now, the other thing which I haven't mentioned, which I just want to finally deal with, is the position of children. Now, again, children that of the parties over a period of time. So it might be a child who's 10, one might be 4, one might be 1. Obviously, the parties are together and that they've had children, and that demonstrates that relationship over a long period of time. That brings me on to the final point. What I talked about today is how do you sponsor your husband or wife to come to the UK. Now, the final point before we finish is how do you sponsor your children to come to the UK. The first fundamental difference is this, that children under the age of 21 can be sponsored to come to the UK where the sponsor is a European national. Contrast that with a situation where the sponsor is a UK national. In that situation, children under the age of 18 can be sponsored to come to the United Kingdom. Over the age of 18, they cannot be sponsored to come to the United Kingdom. So that's the big difference. The age is a big difference. Now, just looking at the evidential aspect of this, you will have to prove that they are obviously your children. Best form of evidence is birth certificates, and what you should really do is submit birth certificates which have been obtained as close as possible to their date of birth. So for example, if they give birth in 2015, ideally you need a birth certificate from 2015, not a certificate which has been obtained now in 2018. That can potentially present a problem. Now, so what I've tried to do today is sort of whiz through how a spouse application can be made by somebody whose sponsor is not British but is a European national. And as can be seen throughout the show, it is much easier for a sponsor to sponsor their husband or wife to come to the UK where they have a European passport. That unfortunately brings us to the end of the show. Inshallah, we'll be back next week on Monday at 6 o'clock. Until then, Assalamu alaikum.